Consider the nominations of Mr. Brad Carson to be Undersecretary of Defense for Personnel and Readiness, Ms. Jennifer O'Connor to be General Counsel of the Department of Defense, and Mr. Todd Weiler to be Assistant Secretary of Defense for Manpower and Reserve Affairs. We welcome all of you here this morning, as well as any members of your families. As is our tradition, at the beginning of your testimony, we welcome you to introduce any members of your family joining you this morning. Mr. Carson, the Department of Defense recently announced 2 rounds of Force of the Future proposals. However, the Department has never provided this committee any information whatsoever on these proposals. I am informed that you are the main architect of the Force of the Future. As an individual who previously appeared before this committee as a nominee to be the General Counsel of the Department of the Army and later as Undersecretary of the Army, your failure to provide information to this committee stands in stark contrast to the commitment you have previously made to provide witnesses and briefers in response to congressional requests. The Department has repeatedly ignored my request for more details and refused to brief me or my staff. You will be expected to answer questions from the committee today on the record. Many of these Force of the Future proposals appear to be solutions in search of a problem. We are eager to learn what clearly identified problems you propose solving with your proposals, and of course, we want a full description of the background research, cost analysis, and analysis of the impact on military readiness that served as the foundation for the development of such proposals. I find it deeply disturbing that you are proposing to add expensive fringe benefits allegedly aimed at retention during a time when we're asking 3,000 excellent Army captains to leave the service who would have otherwise chosen to remain on active duty. From my perspective, this initiative has been an outrageous waste of official time and resources during a period of severe physical constraints. It illustrates the worst aspects of a bloated and inefficient defense organization. I look forward to your explanations and empirical data on this important issue. Ms. O'Connor, the General Counsel of the Department of Defense, is the Chief Legal Officer and the advisor to the Secretary of Defense on matters involving our nation's fighting forces. The enormous responsibility for this position is reflected in the names of those who have served as DoD General Counsel: Secretary Cyrus Vance, Paul Warnke, Jamie Gorelick, Judith Miller, William Haynes, Secretary Jay Johnson, and most recently, Stephen Preston. These individuals and others who served in this key position brought a depth of legal judgment and experience in national security. This is a position where, if confirmed, you must be the voice of authority for a range of issues with serious national and international implications, ranging from our nation's freedom to navigate wherever and whenever needed, our ability to fight and win using legal authorities ranging from rules of engagement to authorizations for the use of military force, and our responsibility to provide secure and humane detention of unlawful combatants. I hope you've come prepared to address how you would approach these pressing issues today. Mr. Weiler, you are nominated for a newly created position within the Department of Defense as a result of a reorganization of the Undersecretary of Defense for Personnel and Readiness. As this is a new office, we are interested to hear how you envision this position fitting into the broader Department of Defense organizational structure and what role this office will play in managing DoD personnel. Again, I thank the witnesses for their willingness to serve and look forward to hearing their testimonies. Senator Reed.
Thank you very much, Mr. Chairman, and I join you in welcoming our nominees, and I thank you for holding this hearing to fill important civilian vacancies in the Department of Defense, all of which directly or indirectly impact our servicemen and women in the civilian workforce of the Department. The positions for which these individuals have been nominated involve significant and challenging duties. Mr. Carson, who has been nominated for the position of Undersecretary of Defense for Personnel and Readiness, has significant experience in the private sector and government that should prepare him for this position, including service as the General Counsel of the Army and the Undersecretary of the Army. Mr. Carson is a Rhodes Scholar who served on active duty in the Navy as recently as 2009 when he was deployed to Iraq. Ms. O'Connor, nominated as the next General Counsel of the Department of Defense, is currently serving as a Deputy General Counsel for the Department, giving her significant insight into the legal challenges the Department faces. Prior to that, she was Deputy White House Counsel, where she worked with attorneys from the Department of Defense and other federal agencies on a wide variety of legal issues. Ms. O'Connor has extensive service in government and in the private sector, all of which will serve her well as DoD General Counsel. The DoD General Counsel is the primary legal advisor to the Secretary of Defense, and as such, it is extremely important that this position be filled as soon as possible. Mr. Weiler, nominated to be the first Assistant Secretary of Defense for Manpower and Reserve Affairs since the position was recognized in the 2015 National Defense Authorization Act, also brings significant government and private sector experience that will serve him well in this new position. Mr. Weiler is an Army combat veteran, serving in the Gulf War prior to serving as a Deputy Assistant Secretary of the Army for Manpower and Reserve Affairs in the Clinton administration. For the past 16 years, Mr. Weiler has worked in the private sector, but has continued his involvement with wounded warrior and suicide prevention programs, which will also serve him well in this new position. Again, I thank you, Mr. Chairman, for holding this hearing, and I look forward to hearing from our witnesses.
Thank you. These are standard questions that are asked of all civilian nominations, and I would appreciate it if, in response to these questions, that you would answer yes or no, or I will or won't. In order to exercise its legislative and oversight responsibilities, it's important that this committee and other appropriate committees of the Congress are able to receive testimony, briefings, and other communications of information. Have you adhered to applicable laws and regulations governing conflicts of interest?
Yes.
Will you ensure that your staff complies with deadlines established for requested communications, including questions for the record and hearings?
Yes.
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 Will you cooperate in providing witnesses and briefers in response to congressional requests?
Yes.
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 Will those witnesses be protected from reprisal for their testimony or briefings?
Yes.
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 Do you agree, if confirmed, to appear and testify upon request before this committee?
Yes.
Yes.
Do you
Yes.
agree to provide documents, including copies of electronic forms of communications, in a timely manner when requested by a duly constituted committee, or to consult with the committee regarding the basis for any good faith delay or denial in providing such documents?
Yes.
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 Have you assumed any duties or undertaken any actions which would appear to presume the outcome of the confirmation process?
No.
No.
No, sir.
Mr. Carson, in your response to advanced policy questions from this committee, you state you were not serving in violation of the Federal Vacancies Reform Act. You have now indicated that you did not take any action that would appear to presume the outcome of the confirmation process. I disagree. For the record, on November 30th, 2015, I notified President Obama by letter that Mr. Carson's appointment as the Acting Undersecretary of Defense for Personnel and Readiness violated the Federal Vacancies Reform Act of 1998. Without objection, a copy of that letter will be included in the record of this hearing. The law in this area is well established. Last August, the United States Circuit Court of Appeals for the District of Columbia in the case SW General Inc. v. National Labor Relations Board ruled that the Federal Vacancies Reform Act applies to all acting officers, and that an acting officer serves in violation of the Federal Vacancies Reform Act when he or she occupies an acting position while being nominated for that position. The court further ruled that actions taken by any person who is not acting in compliance with the Federal Vacancies Reform Act shall have no force or effect and may not be ratified. As the court noted, advise and consent is more than a matter of etiquette or protocol. It's a structural safeguard intended to curb executive abuses of power and to promote a judicious choice of persons fulfilling the choices of the union. Without objection, a copy of that decision will be included in the record. Just this last week, the Inspector General of the Office of Personnel Management notified the President's Acting Director of OPM, Beth Colbert, that she too was serving in an acting capacity in violation of the Federal Vacancy Reform Act, citing that same D.C. Circuit case. Following the decision of the D.C. Circuit Court, it appears that Mr. Carson's service as the Acting Undersecretary of Defense for Personnel and Readiness from on or about July 8, 2015, violated the Federal Vacancies Reform Act. If so, all actions you took, Mr. Carson, while serving in that acting position are null and void and may be subject to legal challenge in the federal courts. In my letter to the President last November, I requested that the committee be informed of the administration's proposed actions with regard to any actions taken by Mr. Carson while serving in an acting capacity. As of today's hearing, the administration has not provided that requested information. You currently serve as Acting Principal Deputy Undersecretary of Defense for Personnel and Readiness, a position you have held since you were appointed by the President on January 5, 2016. According to the official Department of Defense website, quote, the Principal Deputy Undersecretary of Defense for Personnel and Readiness is delegated full power and authority to act for the Undersecretary of Defense for Personnel and Readiness and exercise the powers of the Undersecretary of Defense for Personnel and Readiness on any and all matters that the Undersecretary of Defense for Personnel and Readiness is authorized to act, except in those areas where delegation of the Undersecretary of Defense for Personnel and Readiness authority is otherwise restricted by higher authority or prohibited by law, unquote. I'm not convinced that your initial Vacancy Act violation is remedied by moving to another acting position in which you exercise all the authority and powers of the original vacant position. This committee takes with the utmost seriousness the Senate's constitutional duty to give advice and consent on presidential nominations. In recognition of that constitutional duty, recent administrations have issued guidance to nominees on the actions they must avoid. If followed, that guidance allows nominees to prepare for the important duties and responsibilities that they will undertake if confirmed by the Senate. Nominees disregard that guidance at the peril of presuming confirmation. The Department of Defense Office of General Counsel issued a memorandum for prospective nominees for Senate-confirmed presidential appointments in the Department of Defense on January 15, 2009. The memo identifies 10 specific problems to avoid. Without objection, a copy of that memo will be included in the record. That memo stipulates that, quote, until you are confirmed, you must act in a manner consistent with your roles, which is limited to preparing for your new duties and responsibilities, unquote. The committee notes for the record that in addition to the general prohibition on appearing to presume confirmation, your actions as described in your response, the committee's advanced policy questions, suggest you have violated nearly all of those principles. You have hired staff as special assistants. You have represented the department with outside organizations, think tanks, federal labor unions, foreign military officials, and the media. Therefore, your conduct during the period you were serving as acting Undersecretary of Defense and your continued conduct while serving acting Principal Deputy Undersecretary of Defense for Personnel and Readiness, as described on the official DoD web and by your conduct, is contrary to the guidance of the DoD General Counsel memo and is inconsistent with the time-honored principle that presidential nominees must not presume Senate confirmation. Senator Reed, do you have any comments or questions?
Mr. Chairman, my only comment is that you've raised significant issues, which is the purpose of this hearing, to allow the witnesses to respond to those issues. Thank you, Mr. Chairman.
Thank you. In the opinion of the chair, the nominee has not adequately addressed the violations of the Federal Vacancies Reform Act identified in my letter to the President or in the advanced policy question responses. Further, it appears the nominee has presumed confirmation against the sound guidance by the DoD General Counsel and contrary to the independent constitutional authority of the Senate to give advice and consent prior to confirming a presidential nomination. The committee will give due consideration to these matters. Mr. Carson, you may comment on these matters, and you may proceed with your opening statement. Mr. Carson.
Thank you, Senator McCain. Senator Reed, thank you for holding the hearing. This is, as you mentioned, my third appearance in 4 years as I have been nominated to various positions at the Department of Defense. I can tell you have many questions for me. I will forego a more formal opening statement and submit that for the record. If I may just say a few words of thanks. First, to President Obama for nominating me to this position, to Secretary Ash Carter for placing his faith in me, to the people in the Army. I tried to contribute as much as I could to the U.S. Army in 2 jobs there, but I took much more from them, and I leave those positions with an awe for their sacrifice and for their service. To the great people at Personnel and Readiness who I've had the chance to serve alongside with now for 9 months. They have one of the largest, most controversial, most important portfolios in the Department of Defense, if not the entire government, and I am honored to work alongside them. And finally, to my wife behind me, who has been a fellow traveler in many adventures, I am grateful to her as well. I look forward to your questions.
You do not wish to respond to my comments.
Sir, I would simply say this. I never asked to be the acting Undersecretary of Defense for Personnel and Readiness. I was the Undersecretary of the Army, a terrific job. When Secretary Carter came to me and asked if I would take this job, to be, I think, the 9th person over the last 7 years to hold the difficult job. At that time, the orthodox interpretation of the Vacancies Act was such that there was no legal question at all about my appointment as acting Undersecretary. When we received your letter, I was subsequently asked to resign the position of acting Undersecretary of Defense, which I did. I became the acting principal deputy. And every act I have taken since then is consistent with the role of the acting principal deputy. And in no way have I presumed confirmation. No statement of mine will ever be found that suggests that, and no action of mine will state to that effect either.
Thank you. Do you wish to introduce any of your family members?
My wife, Julie, who is right behind me.
Welcome. Ms. O'Connor.
Thank you, Mr. Chairman, Ranking Member Reed, and members of the committee. It's an honor, a great honor, to appear before you today as the nominee to be the General Counsel of the Defense Department. I wouldn't be here but for the dedication and support of my family and my colleagues. In particular, I want to thank my wonderful husband, David, and my children, Ian and Dylan, both of whom are here. And I also would like to thank...
Welcome.
Thank you. I also want to thank and introduce my father, Austin O'Connor, and his wife, Mebeth. He's a former enlisted Army MP, and he's here today as well.
Welcome.
I'm also grateful for the confidence placed in me by President Obama and Secretary Carter, and for their support of my nomination. If confirmed, I will pledge my continued personal commitment to the rule of law. I will work to ensure that the department remains in full compliance with all applicable law. And I will also pledge to keep in mind the importance of protecting our country from national security threats, and always to work to help define lawful paths to support our military and civilian personnel as they work to achieve our mission objectives. Following the Secretary's lead, I will pledge my best efforts to ensure that the Armed Services Committee are kept properly informed in furtherance of your critical oversight responsibilities. And finally, and most important, as General Counsel, I pledge to serve the people who serve us, the fine men and women of the U.S. Armed Forces, and the civilian personnel who support their mission. As the daughter and niece and cousin of 7 former service members who span the Army, Navy, Air Force, and Marine Corps, I've long been inspired by their commitment to this country. And having worked closely with our men and women in uniform over the past months as the Deputy General Counsel at the Department, I'm honored to continue serving them as the General Counsel of the Department. If confirmed, I will make every effort to live up to the confidence placed in me, and I want to thank you for the opportunity to be heard today. I also want to wish speedy recovery to Senator McCaskill, and I look forward to your questions.
Chairman McCain, Ranking Member Reed, and distinguished members of the committee. I'm honored to be here today as the President's nominee for the Assistant Secretary of Defense for Manpower and Reserve Affairs. If confirmed, I look forward to working with you and your staffs on the challenging issues that face the Department in this year and set a pathway forward for future MNRAs. I would like to begin by thanking my family, friends, and colleagues that are here today. They're the backbone to my success in and out of government service. Beginning with my spouse, while unable to be here, has certainly been my rock for over 8 years and demonstrates every day the perseverance and strength of character needed for strong family and a successful career. I would also like to recognize someone else that is not here. In my last year of college and only months before I was commissioned in the Army, my mother passed. But I know that she would be very proud of her 3 boys. She taught us the importance of selfless and altruistic service. I'm pleased to be joined here today by my younger brother, Dana, and his wife, Angel. He serves with the FAA and recently transferred to D.C. from Oklahoma. They're a light for so many as they have set the example by demonstrating courage and determination in life that comes from facing struggle and sacrifice. All of these folks, family and friends, set the example of compassion and caring that I hope to bring to this position. If confirmed, I commit to bring the lessons that I have learned from government and private sector service to the MNRA family. I commit to enter each day with a constant ear to the voices of our service members and their families. I realize that this is a new position and that it has great challenges, from total force personnel policy changes to benefit adjustments, efficiencies, and continued mobilizations. These are the challenges that I will not shrink from, but will face each day with a determination and resolve to improve the department while maintaining compassion for its people. It has been many years since I served in the Army and later as a Deputy Assistant Secretary to that service, but I look forward to bringing that experience and a diverse background in government service, entrepreneurial commercial leadership, and nonprofit advocacy to the issues that face our service members and their families. I have always remembered from my entry into the Army, mission first, people always. I thank you for this humbling opportunity, and I look forward to your questions.
Thank you very much, Mr. Weiler. Mr. Carson, you've briefed the media, federal labor unions, think tanks, and foreign governments on your Force of the Future initiatives, but you've never briefed this committee. Why?
So there's never been a single request of me to brief this committee that I have turned down.
So it's up to us to ask for a briefing from you rather than you to offer a briefing to us.
I have offered on many occasions. I am told by our legislators.
Formally, you have requested to brief this committee?
I have been told on many occasions the committee has asked us to give information. My name has been volunteered to come over here, as Mr. Varney would tell you. I showed up at the SASC one morning, apparently.
It's not how it works, Mr. Carson, and you know it and I know it. The way it works is that we have something that you think the committee and Congress should know about, then you ask to come over and brief the committee and members of Congress, and we have no record of you doing that.
The matters we've worked on Force the Future and other matters at PNR have been pre-decisional. They were inappropriate to brief to the Senate at that time.
But you could brief labor unions, media, think tanks, and foreign governments.
I did not brief any of them with information I did not give to the U.S. Senate. The labor unions are important to notice. They have pre-decisional rights.
What do you mean that you didn't give to the U.S. Senate? How did you give it to the United States Senate?
We delivered the reforms, version 2.0 of Force the Future, to the Senate Armed Services Committee, sir.
And you never asked to come over and brief the committee on those proposals?
We have told the committee on many occasions. Mr.
No, you
Varney,
never asked, Mr. Carson. You're parsing words. When members of Congress have major policy decisions, when the administration has major policy decisions, and certainly these are far-reaching, they ask to come over and brief the Committee of Oversight. That is standard procedure. You didn't do it, Mr. Carson.
Twice, sir, I have been to the Senate Armed Services Committee.
I would be very interested in seeing a written record of that happening, because I know of no one on this staff nor any member who has been briefed by you or requested to be briefed by you. Perhaps you can correct the record. We'll leave the record open for you to correct that record if that is indeed the case. How many special assistants have you hired for your office?
Sir, over the last 7 or 8 months, we probably have 4 or 5 special assistants.
4 or 5 special assistants, and the 32,000 employees in the PR&R organization, you needed to hire additional assistants.
Sir, these are political appointees. We are very fortunate at PNR that because of the exciting work we are doing and the way that the organization is handling some of the most important national security issues, that people have wanted to work for us. And so we've not added to the aggregate Department of Defense headcount in any way, is that people have wanted to come and be a part of this. Brilliant young men and women who will someday lead the Department of Defense.
Unpaid?
No, sir, but they were working elsewhere at the Department
I
of Defense
see.
when they were seconded to our office.
A recent article in The Atlantic said about your leadership of this team, quote, "He soon turned full-time. The all-consuming initiative. His small staff worked around the clock from a cramped office in the Pentagon's E-ring. By early summer, inflatable air mattresses started appearing under many of their desks." At what point did you involve the services in developing your Force of the Future proposals?
They were involved from the very first day, sir. It's important to remember that the genesis of the Force of the Future initiative was from Secretary Carter himself while I was still the Undersecretary of the Army. I fell into the job and onto the 3 working groups that were already established with representations from both the uniformed and civilian side of all the services. We had meetings 6 hours a week. Hundreds of people were involved from the services. Over the last 8 or 9 months, the services have been intensely involved, from the service chiefs to the service secretaries to all of their personnelists, so much as line item editing with the various chiefs of staff of the services.
It's very interesting because that is not what we hear from the uniformed military. That's a very interesting, different view of events. Did you bother to read the Department of Defense General Counsel memo on presumption of confirmation and what actions you should avoid?
I've read that, sir, yes.
And yet you violated almost all of them. Do you believe you're above the rules set by this committee?
I've never violated that memorandum, nor had any presumption of confirmation, sir.
Of course, that is not the view of a circuit court, your actions, but
As I noted, I resigned the position immediately upon being told of your letter that was sent to the Department of Defense.
and I just gave you a quote, sir, concerning the interpretation of the law, which was recently as a result of a court decision. So that's your view versus that of the circuit court. So I have no further questions, Senator Reed.
Thank you, Mr. Chairman. Mr. Carson, just to clarify, you were acting Undersecretary of Defense for Personnel and Readiness when the circuit court made a decision that since you were a nominee, you could not hold that position. And you, in response not only to the circuit court, but the letter from the committee, took affirmative action and resigned from that position. Is that correct?
Yes, Senator.
Then you became the principal deputy assistant to that position, effectively. And so your conduct then would be measured by what is appropriate for the principal deputy assistant to do, not only within the building, but contacting other people outside. And in your view, you complied explicitly and sincerely with the duties of the principal deputy assistant. Is that accurate?
Yes.
That's accurate. With respect to the building the first, the new force, the initiative that you've worked on, it's been the subject of the questions. I understand, and you might provide some perspective, that the Deputy Secretary of Defense and the Vice Chairman of the Joint Chiefs of Staff were intimately involved in this process. Can you describe their roles?
Yes, as I mentioned, the process started long before I became the acting Undersecretary of Defense last spring, and the working groups developed more than 120 position papers that filtered up to me. After we ourselves distilled those, the Vice Chairman of the Joint Chiefs and the Deputy Secretary of Defense got a group together composed of the Vice Chiefs of the services as well as the Undersecretaries, the implementation group it was known as, and we had exhaustive meetings about what to do on the force of the future and the right thing to recommend to the Secretary of Defense.
So in effect, certainly at the most senior levels, the uniformed personnel, the Vice Chief and others were involved on an almost day-to-day basis in this construct. Is that accurate?
Yes, and the ones and the MNRAs and the services were as well.
Good. Ms. O'Connor, you have a very challenging job before you, and could you identify quickly what you feel are the most immediate issues that the new Defense Counsel would face?
Senator, you're right. There are challenging issues in front of the department. Some of the most immediate ones are the ongoing issues that the General Counsel faces, which is to provide accurate and as quick as possible and as supportive as possible legal advice to the Secretary regarding the conflicts that we're engaged in to fight ISIL and our other enemies in the Middle East. Other issues that are facing the department are as this committee has raised and statute has directed, and also the Secretary has made a commitment to, is addressing sexual assault. And that's an issue that the General Counsel works on alongside the policy leaders of the department. There are a wide range. It's a job that has a wide portfolio. It includes personnel matters. It includes cybersecurity, legal analysis as well. And obviously, we have the issues that were presented by the administration to this committee and others on Tuesday regarding how to handle the ongoing detainees at Guantanamo Bay. That's just a sort of flavor of some of the big issues that are facing the General Counsel.
Thank you. And Mr. Weiler, you have extensive career in business as well as experience as a combat officer in the Army, and you're taking on a role that is essentially a new role. Do you have a sort of several major issues you'd like to address immediately?
Senator, I think that one of the major issues, because this is a new office, are the naturally occurring processes that occur as such. So it will be ensuring that the staff is working across functional lines. I also see the need to reassure our reserve components, because this was just a reserve affairs position, that actually the representation in more functional duties across the portfolio will help the reserve components by having representation in those other areas. So I see those as major challenges right away.
Thank you very much. Thank you, Mr. Chairman.
Senator Inhofe.
Thank you, Mr. Chairman. Mr. Carson, known you for a long time, right?
Yes, sir.
And while we have had differences in the past on political issues, we've gotten along very well, haven't we?
Yes, sir.
You've been up for confirmation several times, and has anyone on this panel been a stronger supporter of you than I have?
No, sir, I don't think so.
Yeah. Well, having said that, I was disappointed when complaints were brought to my attention and to the attention of other members of this committee about your leadership and the command environment that exists in the office of the Undersecretary of Defense and Personnel in Readiness. I've read reports and I've been briefed, as others have, regarding I'm choosing the words very carefully here, a hostile work environment that has been fostered under your leadership in the office of Undersecretary. Now, these are whistleblower things, and I understand that sometimes they're with merit and sometimes without merit, and so I have no way of knowing. So, but it is extremely concerning that they have been called to my attention. Are you aware of any of these issues?
No, sir. And I would strenuously object to this characterization. I've never heard that allegation, and people have many means to make those kinds of allegations at the Department of Defense through.
Though you've answered my question. Let me ask you, are you familiar with what a command climate assessment is?
Sure, absolutely, sir.
Have you had a command climate assessment in your office of you, particularly, your leadership?
No, we don't do that for civilians. The military does that, but it's not typical for the civilians to do that.
But is it permissible?
Yes, certainly. I'd be happy to do that.
All right. Well, that answers my question. I think that's serious, but it may not be true. And so I'm going to request a command climate assessment, and I'm going to ask the committee to delay a vote to report your nomination until we get that. It can be done very quickly.
Absolutely, sir. I can assure you there is no hostile work environment. And listen, there is, I will dispute that allegation.
Yeah, and I hope that's the case. Ms. O'Connor, I told you I was going to ask this question. I'll preface it, which I didn't preface to you. It's been my observation in the last 7 years that this president has had total disregard for the law in many cases, specific cases when I think it was in the National Defense Authorization Act of 14 when we put the requirement on for a 30-day notice before anyone being released from Gitmo, and it was 5 months later that the Taliban 5 were released in disregard of that law. Now, on Tuesday, the president announced his plan for the closure of Guantanamo. The plan also includes the transfer of 35 of the remaining detainees aboard to be shipped to 60 to the United States soil. These remaining 60s are the highest risk that are out there. Now, every year since 2009, Congress has passed laws to prevent both the closure of the base and the transfer of detainees to the U.S. soil. In your answers to our advanced policy questions, you answered questions on your view regarding language in the fiscal year 16 NDAA that, again, prevents bringing terrorists detained at Gitmo to the United States. So you've had a chance to study this, and I'm just asking, Legally, can you see anything in here that would allow the president to legally circumvent those aspects of the law that would preclude those releases or funding of transferring it to the United States?
Senator, as I think I said in the advanced policy questions and in answer to your question, it's the position of the department that the provisions that you cited prohibit the transfer of detainees from Guantanamo Bay to the United States. The Attorney General testified about this yesterday, and she said that was her view as well. That's my view as well.
Okay, well, I think that's very clear, and I appreciate your answer, and we'll be hoping that that doesn't happen. Thank you, Mr. Chairman.
Let me just follow up. Do you believe that the president was following the law when he failed to notify the Congress within 30 days of the release of the 5 prisoners who were released in exchange for Bergdahl?
Senator, my understanding of that, and it wasn't something I was involved in, but I have an understanding
Well,
of it.
I want your legal opinion, Ms. O'Connor.
So my understanding of that is that the department has provided in letters to this committee as well as to the GAO.
I'm asking
its
for
legal
your
analysis.
opinion, Ms. O'Connor.
So my understanding of it is.
I'm asking for your legal opinion. You are a lawyer. You are going to be the chief legal counsel. What is your view? Did the president, did he or did he not violate the law when he failed to notify the Congress 30 days ahead of the release of the 5 prisoners in exchange for Bergdahl? That's a pretty straightforward question, Ms. O'Connor.
The administration didn't give 30 days' notice. The legal analysis of why that was appropriate is that the president.
I will ask you for the last time for your opinion. I just asked you a series of questions if you would give your opinions to this committee when asked. I'm asking you whether the president acted in violation of the law when he did not notify the Congress 30 days ahead of the exchange of prisoners for Bergdahl.
In the circumstances presented, it was not a violation of the law.
So it is your opinion that it was not a violation of the law?
In the extremely unusual circumstances there, it was not.
Thank you.
Thank you, Mr. Chairman, and thank you all for your service and coming here today. Let me say, I'll address this to Ms. O'Connor first. I feel strongly that we need an open debate about the authorization of use of military force, AUMF, as you know, related to our conflict with ISIS. I think we owe it to the American people what our purpose and direction and how we're going to take this on. And in reviewing your advanced policy questions for the committee, I was glad to see that although you felt like the administration's current legal authority was adequate, you support getting a specific statutory authorization to use military AUMF, and I really appreciate that. So I think I'd like to know, in your opinion, what would having an AUMF in the fight against ISIS clear up with the current mess we're in now with an all-encompassing AUMF?
Senator, it's a good question. The current legal authority for the battle against terrorism against ISIS that we're engaged in is from the 2001 AUMF.
Correct.
And that provides the legal authority for all the activities that the department is engaged in. The administration proposed a new AUMF for other reasons, including the perspective that it would be important to our allies, to our enemies, and to our troops for all of the branches, the 2 branches of government together to issue a current vote of support for the efforts there. And I think in general, statutes that are old are statutes that should be taken a look at.
So you're encouraging basically we should have a new AUMF. You still feel that's strong about it?
Certainly, it seems like it would be a good idea.
Thank you. Mr. Weiler, if I can, when I first became a member of the Senate and came to the Armed Services Committee, at that time, Admiral Mullins came before us and it was asked, what's the greatest threat the United States of America faces? Which I would ask all of you to think about that. His answer, without even blinking or thinking, was the national debt. The national debt at the time he came before us was $14 trillion. We're at $19 trillion. People think we might go as high as $22 trillion very shortly. And I know everybody with sequestering, we have a lot of problems and a lot of things that we're concerned about, protecting the homeland is at the forefront of all this. How do you think the national debt affects our ability to defend our country?
Senator, I think that it affects probably all things in the government, and in particular, how we fund our forces and keep them ready.
How does it compare to some of the global challenges that we're facing as far as the imminent threats?
I think
Do you rate it as high, or?
I would definitely say it is high, yes, Senator.
Yeah, it's a challenge. It really
where
is.
global crises may come and go, this has been a long-term issue and will continue to be so.
Yeah. Thank you, Mr. Carson. Also on yours, I was wanting to ask. I think when you were Undersecretary of the Army, you had said that an event that brigades in the Army National Guard are not one-for-one substitutes. I think, but I've read your article, and I think you were complimentary in what the reservists do, the National Guard, and how I think all of you, and both you two are especially going to be involved with the Guard. And only thing I would say, as a former governor, the Guard's near and dear to me and to all of us, but I was able to see the Guard up close and personal, what they do. If it wasn't for the Guard, I don't think half the people, I don't think that most of the majority of the people in this country would even know the military, the strength of the military, the sacrifices of the military. They keep it real. And we continue to see the reduction in forces there, but also we see the increase of contractors. I have a hard time justifying why we still have such a strong contracting force, and we're basically dwindling away our National Reserves and our National Guard. So if you could speak to that, sir, the National Guard strength and the Reserve strength.
Absolutely, Senator. I am a great admirer of the reserve component, both in the Air Force and Army Guard and the various reserve components across the entire Department of Defense. And I served in Iraq with the Red Bulls, the Minnesota National Guard, who were given the weighty responsibility of running an entire section of the country. And so I know firsthand how remarkable they are. And today that same unit is in the Sinai, doing an important mission for us as well. So you'll never hear a negative word about the Guard or Reserve from me.
Do you think they're capable to do the same one-on-one job?
Absolutely.
Or is the training different, or is the training not up to speed to what the regular Army is getting?
I think the regular Army gets more of that training, but I think when the National Guard has the training opportunities and is getting ready for deployment, they can do the same missions as the active component.
Anybody else have any comments on that, the Guard and Reserve units?
Completely agree, Senator.
Thank you.
Thank you, Mr. Chairman. You know, the Defense Department is the great department of the United States government. It takes more than half of the discretionary spending, $600 billion a year. This committee has a duty, in my opinion, to ensure that the top officials who operate that department are really the best that we can have. Yes, you would want to reflect the views of the President in many ways, but you have duties that go beyond that. You have a duty to faithfully adhere to the law, to never take a position that's contrary to the national security interests of the United States. And there's a growing unease that we're seeing, particularly in the latter days of this administration, less and less professionals and more people holding a position that basically will be politically loyal to the White House. I mean, not just the way it is. And I'm concerned about it. Mr. Carson, I think I want to make clear in response to the follow-up on Senator McCain's question, and that you claim you've met with the committee on the force of the future proposals, and I think the members of this committee would know if that's happened. I believe you did not. Are you saying you actually met with this committee to discuss force of the future proposals?
I met with the staff in August of last year, sir.
When did this force of the future start?
It started in April or May is when I got involved. It actually started in February, about 5 months earlier than that.
Well, this is an important matter. And what we know and what we believe, from what I've understood from senior defense military officials, that you met at great length with a select group.
Without infringing on the Senator's time, I'm informed by staff, Mr. Carson, that you came over for a pre-confirmation conversation, but not specifically on the force for the future. I guess we'll have to clear it up for the record that our staff says it was not on Force the Future, it was on your pre-confirmation conversation.
It is worth discussing all of this because obviously it's an issue of concern to the committee. I showed up in August and the conversation was about Force of the Future. I had another scheduled event over here where apparently we had our wires crossed and Mr. Varney told me I needed to come back another time. We delivered the reform proposals to the committee. On various occasions, our legislative affairs staff, when the committee asked for experts to come talk about Force the Future, said that Mr. Carson himself is the expert and come talk to you, and that request was turned away.
Well, Mr. Carson, we will leave the record open, and because that is clearly not the depiction of events by my staff, and nor do I know of any senator that received a request from you to brief them on Force of the Future. Senator,
If I may add one more thing to that, I am happy to go anywhere to brief it. I will come this afternoon and walk through all of the spreadsheets, the analysis. So I have been on the road trying to talk to people about what we're doing, and I'm happy to go anywhere, anytime, to talk to anyone about these issues, and have never turned down any requests.
It's nice of you to classify us as anyone, Mr. Carson. There's a responsibility that most people feel they have to Congress. Senator Sessions, please proceed.
Let me tell you what I'm concerned about. We hear that you met with a group of people and went far down the road in developing this plan of the Force for the Future before senior military people were really involved, and that they are frustrated about it and do not feel like that they've been properly consulted. And we will pursue this further, but I'll give you a brief chance to respond to that. I know you've given your side of it, that you had many meetings. All I'm telling you is people didn't feel like they were engaged in it.
They were very engaged in it, Senator, from the very start of this. I can assure you of that.
All right. That's your position. Others have a different view, I have to tell you. And there's an unease here because the White House is widely perceived to be suspicious of the military and have not been comfortable with the recommendations they make, and have in many ways sought to get around that. And that's why we're raising it, just to be frank with you. And top people have said that the White House is disrespectful and suspicious of military advice. So I just hate to say that. Ms. O'Connor, have you ever served in the military?
No, sir, I have not.
Have you ever read the Uniform Code of Military Justice?
I've certainly read provisions of it. I haven't read it end to end.
You ever participated in a court-martial or Article 15 or made a decision about that?
I've not been a military lawyer.
You had a period of time at the IRS. You worked on cleaning up, trying to move through the lowest learner matter. Is that right?
I'd be happy to describe that if you'd like me to.
Did you work on those issues?
So when I was at the IRS, as I'm sure you recall, when the agency faced an incredible crisis, the president fired the leadership of the agency and brought in an acting commissioner for a temporary period of time until a new commissioner could be confirmed. That acting commissioner brought a small team with him for a number of purposes. One was to try to manage the agency in the interim, try to fix some of the management problems, and an important piece of his job.
Well, my time is about up, and I just would note you also was at Homeland HHS during the Obamacare rollout, which didn't go so well. But my concern is, isn't it true that there are thousands of former JAG officers, thousands of lawyers who specialized in military issues, who've served in the military, who understand these issues, who've dealt with authorizations for utilization of military force, who've written papers on it and studied it? Wouldn't some of those who have that kind of experience be a better nominee to the Department of Defense than someone who's apparently had no experience whatsoever in these issues?
I know the time's run. May I answer?
You can
that
answer.
Question? Senator, I'm extremely qualified for this position. I've practiced law for almost 2 decades, and in that practice, it's included practice in the government, working in a number of different positions, with a very diverse range of experiences that cross federal agencies, as well as both at the White House and the Defense Department, where I've worked specifically with the Defense Department and its issues. I also spent 15 years in one of the most well-regarded national security and defense practices in private practice. I think that you are right, that because I have not been in the JAG Corps, the operational issues that those lawyers face are new to me. But in the position that I have been in at the Defense Department, I have had a tremendous experience already meeting the staff judge advocates for the combatant commanders at PACOM and EUCOM and AFRICOM, getting to know and working with the legal advisor to the chairman of the Joint Chiefs, and getting to know the TJAGs. I would expect that in those areas which are new to me, I will rely on their tremendous expertise and advice going forward as those issues arise.
Well, thank you. As a lawyer, I would just say there's almost no issue that will come before you that you won't have to start from the beginning to do your research on. It would be very helpful. We had a nominee in this critical position that sets a legal policy for the Department of Defense who already understands the great issues that the Department of Defense has to deal with. Thank you, Mr. Chairman.
Senator King.
Mr. Carson, your responsibilities in this position, if confirmed, would involve, I note, readiness as well as personnel. It strikes me that in a time of essentially fixed budgets, those two responsibilities are inevitably going to come into some kind of conflict. Can we maintain the proper level of readiness, training, and deal with increasing personnel costs into the not only the immediate future, but the longer term future? Aren't we heading for some real dangerous trade-offs here?
I think there are trade-offs across the budget, especially when the specter of sequestration still looms in a couple of years. But personnel, in many ways, informs the readiness questions. When you talk to the services about their readiness concerns, it's often driven by personnel. Take the Army, for example. The downsizing has created enormous turmoil. They are reconfiguring what's in the BCT. They have 50,000 unavailable soldiers who can't be deployed, 39,000 medically so, 11,000 some kind of legal process. And so the personnel churn and the lack of available people makes a unit unready. And sometimes the training issues for those same people lead to degradation of unit readiness as well.
I'm concerned that we're making decisions and doing drawdowns and force reductions based upon old news. The budget caps essentially that we're working on were put in place in 2011, pre-Syria, pre-ISIS, pre-Ukraine, pre-South China Sea. Do you think we should re-examine those decisions? It just seems like we're reducing our force structure at a time of, as General Clapper, Director Clapper testified, unprecedented threats and danger to this country.
I think there are great dangers on the horizon, Senator. And of course, to meet those, it's not only about the people, as important as they are, it's about having the right kind of equipment, the right kind of training. And so there are trade-offs across the budget to do that. I think the budget submitted by Secretary Carter adequately balances those, but there is no question that, for me, in the era of the all-volunteer force, the continued health of our personnel is something that I'm nothing short of obsessed about.
Often when we're talking about spending, we talk about absolute dollars, $600 billion, and of course that is a huge amount of money, and it is about half of the discretionary budget. I would point out, however, that in 1967, the defense budget constituted 8.6% of GDP. In 1985, it was 5.9%. Today it is 3.3% and falling. So as a percentage of GDP, our national defense budget has shrunk almost by 2/3 in the last 40 years at a time, again, of unprecedented threats. I just think that's information that the public should have. Mr. Weiler, to follow up on some of the other questions about the Guard and Reserve, again, we're talking about declining force levels. As I talk to Guard members and businesses in Maine, a concern is the Reserve and the Guard have become much more of an active duty force called upon repeatedly for repeated deployments, and it's making it harder to maintain the support of the employer community and the potential recruits. How do we balance that, or return to a balance where the Guard and Reserve aren't going to be called upon to such an extent that it compromises the underlying efficacy of that system?
Senator, I think, first of all, is where possible, predictability is extremely critical. Being able to offer predictability not only in the rotation, but to their employers, to the families, and so forth.
That's what I agree. That's what I'm hearing.
When I was in the Pentagon before, we were having a lot of discussions around we need to engage more with the Guard and Reserve to get them part of the total force. And now I see your point on the other side. I think if confirmed, one of the big major issues that I would look into is how we maintain that balance while still keeping the Guard and Reserve an integral part of the total force.
Well, again, as we're declining in force levels, it seems to me inevitable that there will be greater demands on the Guard and Reserve, and perhaps the answer is everybody just needs to know what the deal is going in terms of predictability. But I am concerned that we might undermine support for the Guard and Reserve unless we can clarify exactly what the role is going to be on an ongoing basis.
And I do recognize that, Senator, and I think in particular with not only the family issues, but really involving their career employers, I think that's extremely important. And so certainly if confirmed, it would be an issue that I would be interested in working on.
Thank you. Thank you, Mr. Chair.
On behalf of the Chairman, Senator Cotton.
Ms. O'Connor, I want to return to a question that you had earlier from, I believe, Senator Inhofe and Senator McCain about Guantanamo. You said that current law prohibits, that's the word you used, prohibits the transfer of Guantanamo detainees to the United States. On page 10 of your testimony, though, you twice used the word restrict, which would appear to use some legal room. Does current law prohibit, under all circumstances, the transfer of detainees to the United States?
Yes, Senator.
So you agree with Attorney General Lynch and Lieutenant General Mayville on that point?
Yes, I do, sir.
If President Obama were to order the military to transfer those detainees to the United States, would you expect military officers to disobey that order?
I have no anticipation that that's going to happen, but the position of the department, the position of the Attorney General, in my view, is that the restrictions that are there now are the law, and they prevent that.
Do military officers take an oath to obey the orders of the President?
Yes.
No, they don't.
No, not the President, the Constitution. I'm sorry, I anticipated your question and jumped ahead.
That's correct, because we
Yes.
expect officers, unlike enlisted personnel, to understand the difference and be able to make a tough decision, whether they're a lieutenant or a general, to disobey an unlawful order.
We all take an oath to the Constitution.
But officers in particular are expected to disobey an unlawful order, such as the unlawful order to transfer detainees from Guantanamo to the United States.
They all take an oath to the Constitution.
I want to give you a chance to clear up another question that you discussed earlier about the transfer of 5 Guantanamo detainees in exchange for Bo Bergdahl, who now faces court-martial charges. You said that the law required 30 days' notice. You said that the administration didn't give 30 days' notice, yet you said, quote, it was not a violation of the law, end quote. Do you care to square that circle?
Certainly. And again, I was not involved in the legal analysis and wasn't involved in advice before the exchange or anything. This is something that I understand from having read the position of the department as provided to this committee and others. And the legal position the legal explanation is that in the extremely limited circumstances in which what the President was trying to do was save the life of a service member, that was the assessment at the time, that the operation might not go forward and that his life was in danger if they had to wait 30 days, that in that very limited circumstance, you wouldn't read that provision to prohibit what happened.
Do you agree with that interpretation?
It's not a matter of a personal opinion. I didn't do the analysis, but that's what the legal analysis is.
Well, you'll be the General Counsel of the Department of Defense called upon for such analysis, so I'm asking now for your legal opinion. Do you agree with that interpretation?
That legal interpretation was one that I understand the Department and the Department of Justice worked through together. I don't have any reason to question it, but I have not delved into it myself personally.
Well, it would seem a very plain violation of the black letter of the law. I wonder if that kind of legal gymnastics will be used to warrant a transfer of Guantanamo detainees to the United States.
What I can tell you, Senator, is that I view this position as extremely important, and one that, although it is a position nominated by the President and confirmed by the Senate, it's not a political position, it's a lawyer position. And for us and for me, but for all lawyers, I would hope, certainly for me, the touchstone is the Constitution and the statutes. That is how I will act if I'm confirmed, if I'm fortunate enough to be confirmed by this committee.
Do you consider yourself an expert in congressional investigations and crisis management?
I would not characterize myself that way, no.
Your biography at your previous private employer at your law firm held out your practice areas to include public policy and strategy, congressional and executive branch and multi-state investigations, crisis management, crisis communications, legislative and administrative solutions, and managing public policy risk. Does that sound like you're holding yourself out as an expert in congressional investigations?
That sounds like what the website, that was one of the things that I worked on in private practice, yes.
When you, after 15 years in private practice, left private practice to join the IRS, were you involved in the Lois Lerner matter?
So what I did,
That was a yes or no question.
among my various responsibilities, I worked on providing information as requested to the various investigations that were seeking it.
Thank you. Then you went to HHS during the healthcare.gov controversy. Were you involved in that matter?
While I was at HHS, one of the responsibilities that I had was to help provide information to the congressional committees and others that were seeking information about the launch of the healthcare website.
And then you went to the White House, where you were Deputy White House Counsel about the time the Benghazi Select Committee started. Were you involved in that matter?
One of my responsibilities was to work with the committee as it requested information from the White House.
Have you ever been a chief legal officer of an agency of the United States?
No, I have not.
Have you ever been chief legal officer of an office or department of an agency?
No, I'm serving as the Deputy General Counsel now, and I was the Deputy White House Counsel and had senior legal positions at HHS and at the IRS.
Before 5 months ago, did you ever hold a legal position where the majority of your work centered on national security law?
Well, my position at the White House covered all of the departments, and so that was a piece of what I worked on there. And I also would say that across my government legal positions, many of the issues that are facing different agencies are the same as the ones that face the department. There is privacy law, there is cybersecurity protection law, there's civilian personnel law. There is a wide range of regulations and statutes that govern all of the departments. And frankly, it's an asset, I think, to any department to have lawyers and other professionals who have a diverse experience across other departments and the kind of experience to know how other departments have handled similar kinds of issues.
Well, thank you. My time has expired, but I have to say, given the answers and given the movement from the Lois Lerner to the healthcare.gov to the Benghazi controversy, I'm worried about what this presages for Guantanamo Bay in the last 9 months of this presidency.
On behalf of the chairman, Senator Donnelly, please.
Thank you, Mr. Chairman. And before I begin today, I would like to briefly note my growing disillusionment with some of the hearings we have had in the confirmation process. Not among any of the members here, but it has been my experience that too often some of the nominees come before this committee, smile at us, nod at us, make commitments to us that are then forgotten or discarded as soon as their confirmation goes through. I would rather have a nominee disagree with me than to simply nod, say yes, and then do the exact opposite a few days later. Mr. Carson, last April, you delivered a report to this committee on how the Department of Defense and the VA are working together to ensure we have adequate mental health resources to meet the needs of our service members and their families. On page 10 of that report, it reads, the overall numbers for the service's current mental health staffing indicate near 100% staffing, although the number of billets may lag actual requirements. The number of billets may lag actual requirements. It's a pretty big question mark. Do you believe we have enough mental health providers in the military health system today?
I'm not sure, but I am skeptical of whether we do or not, sir. We have made an heroic effort every year, putting 10% more into the healthcare budget for behavioral health. We have increased the number of civilian and uniform behavioral health providers by 30% and 40% respectively. We've embedded them in primary care clinics. We have been world leaders in this issue. But we know that the questions of PTSD, depression, anxiety, other behavioral health conditions only seem to remain insoluble to us. And so I am closely monitoring it. I work with HA all the time, our health affairs people, on this issue. And so it's a grave concern for me that I'm watching closely.
Well, I'm concerned that DOD isn't effectively assessing how many providers we do need. I want to bring up another report. Last January, GAO delivered a report to Congress that laid out serious problems in how the Department of Defense and the individual services report on their mental health provider staffing needs. On page 20, GAO points out that in their quarterly reports to the Department, the Army does not use the DOD-approved model for assessing provider needs. In the Navy and the Air Force, they don't assess provider staffing needs at all. Instead, they report the number of providers they're authorized to have and then list that as the number they need. I think that's outrageous. And what's even worse is that when the GAO recommended the Department of Defense fix it, the department refused. So, Mr. Carson, if confirmed, what will you do to give the department and the committee an honest assessment of our mental health provider needs?
I can give you my assurances, Senator, that if confirmed, I will do that. As has already been discussed today, there aren't many sacred cows in the Department of Defense I'm not willing to take on. I'm happy to look at that question. I think it's enormously important as issue as anything else we do that's in my portfolio.
Mr. Weiler, my home state of Indiana has the nation's 4th largest Guard contingent. Fighting for policies that help maintain and improve their readiness is a key part of your job if confirmed, and that includes mental resiliency. I'm concerned that mental health programs that work well for active duty service members don't always translate well to meet the very different structure and the very different lives of traditional Guards and reserves. Do you see that as an issue, and how will you work to help improve the mental health services and make sure that what's delivered is what's needed?
Senator, although that particular area is not within the MNRA portfolio, the reserve side is. And I think one of the things that, if confirmed, I would look into would be the manpower analysis that supports the numbers that these units should have. Additionally, I think that we need to look at all of those kinds of family support and service member support services that go to reserve, Guard, and geographically dislocated active component folks, and pay particular attention that those services are being delivered in the communities where they are, as opposed to 100 or 150 miles away at active component installations. So that would be something that, if confirmed, I would certainly look into, is that we're providing that high level of service where those folks are.
Well, there's something else I'd like you to do as well, and that's to get back to me with a list of your priorities, including specific programs or services that you believe can play the strongest role. And then I need you to give me a list of the specific changes that you intend to make, which are the most important, and which are the ones you're going to be working on first. Will you do that?
Senator, I will.
Thank you. Thank you, Mr. Chairman.
Thank you. On behalf of Chairman McCain, Senator Ernst, please.
Thank you, Ranking Member Reed, and thank you for appearing in front of our committee today. Mr. Carson, it is my understanding that your goal is to make the Department of Defense the nation's most progressive employer. Is this true? Just a simple yes or no, please.
Yes, my ambition is to make us the best place to work.
Considering the fact that all military occupational specialties are now open to women to provide greater opportunities to women in the military, which I do support as well, would you consider that it would be also progressive to require women to register for the selective service like their male counterparts?
I think the issue from a policy perspective is this. We should divorce the question of registration from that of the draft. We've had service chiefs talk about the need for a draft. The Secretary, no doubt testifying right now before the House Appropriations Committee on Defense, is speaking to his strong conviction that we don't need a draft. The Center for Naval Analysis just this week came out and said that only 13% of youth are even eligible to serve in the military. But whatever one might think about a contingency in which a draft might be needed, the more interesting public policy question is whether the registration requirement is necessary for it. The GAO has said differently to that.
So
I think we need to do
the stance of the administration, your stance is that there should be no selective service.
No, that is my personal view about it. You asked me the policy questions that this committee and the rest of the nation must address is whether the registration requirement is still a viable, still a necessary one for us. It's one we have to debate among ourselves. The Selective Service Act does not fall under the jurisdiction of the Department of Defense. It would be inappropriate for me to opine about their continued existence.
I think that you are correct, that it is established by Congress. However, the determination to open up combat roles to women was made by the administration. And I think it was done in a manner that was very fast. It is not being implemented maybe as methodically, as deliberative as many of us that have served in the military and, of course, our service chiefs would like to see. So that decision was made by the administration. So I think when we look at selective service, the administration needs to own up to their decision, and then because we do have an existing policy with selective service, they need to make their recommendation to Congress on whether we have women sign up for selective service or not. So thank you for your answer. Ms. O'Connor, where would you stand on that perspective as well? Whether we need a draft or whether women should be required to sign up for selective service?
I don't, as a lawyer, I don't have a view on whether we need a draft. I think that's something that the military departments and other experts in the area should comment on. And I agree with what Mr. Carson said, that there is a policy discussion that needs to take place about exactly what the military's needs are and what the country's needs are, both for registration and for a draft. There's obviously a statute, and so for that to change, it will require an act of Congress. And I think that there needs to be a dialogue on it.
I do think there needs to be a dialogue, and considering the fact that we're trying, the administration is trying to make our military forces, the DOD, the most progressive employer out there, I think then the administration, the DOD, does need to come back with us on these policy discussions, and they need to have an opinion on that. So if there's anything that I would recommend that you take back to the administration, it would be that they need to find a stance on this so that we can be best advised of their position. Mr. Carson, many of the Force of the Future proposals really mirror some of the unique benefits of the Fortune 500 companies. And I think you spent a lot of time working with these companies on their benefits. But I would state that no one at any of these Fortune 500 companies takes an oath to the Constitution to defend us against enemies, foreign or domestic, and these employees certainly do not enlist with the understanding that they may make the ultimate sacrifice to our country in an effort to accomplish their assigned mission or to protect their fellow service members on their left or their right. At what point did you involve service members in your discussion for our Force of the Future proposals?
It is precisely because they make those kind of commitments that they do risk their life, that we have an extraordinary obligation to take care of them.
But do you agree that a Fortune 500 company has a very different mission than that of our military members?
So. Very much so.
Okay. My time has expired. Thank you very much. Thank you, Ranking Member.
Thank you. On behalf of the German, Senator Gillibrand, please.
Thank you, Mr. Chairman, for this hearing. Thank you all for your public service and for your willingness to serve the Department of Defense. I'm very grateful for that. I want to talk a little bit about military sexual assault and some of the work we still have to do to end that scourge. The Department of Defense is required to submit an annual report to Congress each year, providing the number of sexual assault reports made during the calendar year. This number includes the cases that were reported through the military chain of command, as well as the number of restricted reports made to care providers. However, this number does not include those assaults that occurred during a domestic violence incident and that were reported to the Family Advocacy Program. I'm sure you agree that we should be focused on getting a clearer picture of the issue and the scope. By accounting for these cases in a different report, I do not believe the public is getting an accurate picture of the scope of the sexual assault crisis in the military. And I'll just give you some anecdotal evidence. When I reviewed 100 sexual assault cases in 2013 from the 4 largest bases, all reported cases in that 4 bases, what I found was that more than half of the victims were civilians and more than half of those were spouses. Now, those were the only unrestricted reports that were filed. that didn't include reports filed outside of the chain of command. So there's an indication that in that population, it was more than half that were civilians. And so that's not included in the SAPRO report unless it's an unrestricted report. So do you support the inclusion of all reports of sexual assault, including those made to the Family Advocacy Program in the Department of Defense annual SAPRO? And I think this is relevant to Mr. Carson and Ms. O'Connor.
Yes, absolutely. My goal is to integrate and have easily accessible all of the data, not only the sexual assault numbers we've reported in the past, but those from family advocacy and from any other source that they may arise. We need to integrate those into a single report and make sure that those numbers are visible to Congress and other stakeholders.
I think having all the information in order to move forward is important, and if confirmed, I would support Mr. Carson's efforts.
And the goal, I think, would be to, because right now SAPRO is only filled out, it's a confidential survey, it's only filled out by service members. So we could at least extend it to service members' spouses as a general matter. We can't extend it to civilians in the community because that's too difficult. But spouses are within the family of the military, and I think if we did do that, we'd have a much better picture of what the problem looks like. And I'd be grateful for your support.
No, it makes sense to me, Senator.
Okay. I've heard many stories from service members about retaliation after coming forward to report a sexual assault. Not only have I heard this from survivors, but also bystanders who intervened on behalf of a survivor. The department has expressed commitment to addressing retaliation, yet I continue to hear these stories. From each of you, what additional measures do you believe are necessary to prevent retaliation? And what can commanders do to better prevent retaliation and also address it when it occurs?
Perhaps I should start with that, Senator. I've spent the last 6 months at the request of the Secretary of Defense developing a retaliation strategy, which is now basically complete. And it has several lines of effort. The first of all is standardizing across the services what retaliation means. It could be everything from criminal acts that we might involve the military criminal investigation organizations in, to something like social ostracism on Facebook or in the unit itself. So standardizing those definitions, bringing allegations of retaliation into the case management group. It's already looking at sexual assaults where we can track them over time. And much as you have fought on better data for sexual assault, including the inclusion of the FAP data, we need to integrate all of that data into a single source where we know how many retaliation cases are going on, what happens to them, how they're adjudicated. And finally, for the commanders, we have to educate them. So there are many, and perhaps most examples of retaliation don't give rise to criminal activity. They're about social ostracism, devastating, said, but it's not something one takes to court-martial about. So we have to educate commanders about what the available means they have to remedy the social ostracism. At the same time, part of our retaliation strategy is trying to think more smartly about the use of social media, which is often the mechanism for retaliation here. There are free speech concerns that the lawyers have, but good order and discipline is being threatened by the abuse of social media in many cases. And so telling commanders what they can do about that within the limits of the law.
Let me just pause you for a second. Some retaliation, half of the retaliation is either from administrative or from professional. So I appreciate that you're dealing with peer-to-peer, because that's about half as well. But I'm concerned that when the last SAPRO report said, from the perception of the survivor, that 30% was administrative, approximately 30% was administrative, and approximately 30% was professional. Not one case for retaliation was filed. And so we made it possible, I think, in the last NDAA to be able to file a case directly to the IG. But if those cases of professional and administrative truly are retaliation, who's responsible for investigating that, and how come we've not seen any cases?
Well, the IG is responsible for it right now, and there have been a handful of cases, only 6 or 7, which in no way comports with the 62% of respondents
right,
who have said that. So there's a huge gap there that is one of the known unknowns. And so one of our goals is to, by tracking these cases, by standardizing definitions, to understanding what's happening, where they're arising, which will allow us to have better intervention strategies. If it is administrative in nature, the IG will investigate that, but it's a very cumbersome process, as you know. So we have to have other means to hold commanders accountable for what's happening in the units. That's the strategy. But right now, so what's really going on in the retaliation space is a bit of a void for us, and so finding better data is going to be a critical part of the solution.
Thank you, Mr. Chairman. I'm sorry, if either of you two have answers you'd like to give, would you please put it in writing and send it to my office? Because this is a subject matter. And then for the record, the third question is, do you support using a PACER or a PACER-like system so we have better transparency? specifically. Thank you. Thank you, Mr. Chairman.
On behalf of the chairman, Senator Lee.
Thank you very much, Mr. Chairman. Mr. Carson, I'd like to start with you if I could. Last July, it was announced that the Department of Defense would lift the ban on transgender persons serving in the military after a 6-month review period. And then earlier this year, there was a proposed rule that was published in the Federal Register that would allow TRICARE to begin covering hormone replacement treatment for gender dysphoria. How closely have you been involved on those issues, on those decisions, on the release of that proposed rule? And tell us a little bit about why this has become such a high priority within the Department of Defense.
The issue of transgender service is one that the services themselves raise. There are 77 openly serving transgender service members today, 27 in the Army, 37 in the Air Force, 11 in the Navy, 2 in the Marine Corps. And so the services for the last year have been clamoring for guidance about what to do. Because many times service members found themselves in a place with a service member who was among the very best in their unit. They had no desire to separate or administratively punish, but at the same time they read regulations which seemed to prohibit transgender service. And so they were at a loss for what to do. So they came to us, to me, asking for guidance, and that's the genesis of that July memorandum.
With the treatment itself, is there a risk that the treatment itself could interfere with someone's combat readiness while they're undergoing the treatment or after treatment?
Very little risk of that.
Now, I'd like to turn for a minute to the quote that Senator Ernst shared with you with respect to your intention to make the Department of Defense, quote, the nation's most progressive employer. At a time when we are reducing total force numbers, what specific warfighting and military readiness needs have you identified that would be advanced by doing that? In other words, how does becoming the nation's most progressive employer help you enhance military readiness and our combat mission within the Department of Defense?
Everything we have done is to improve the combat mission of the U.S. military, making us a place where you believe that your personal aspirations and professional ambitions can be reconciled, making it a place where you believe you can raise a family and continue to serve, allows us to recruit and retain the right kind of people. Both of those issues are looming crises for us. And so this is about saying to folks that you should come and be a part of us.
Now, when I talk to people who are in the military, who are either in the military now or are considering a possible future in the military, they tend to express concerns that go along the lines of making sure that they will receive adequate training, that the equipment that they will need to protect our country's national security will be up to par, and things like that. They're also concerned about things like how we treat our veterans and how we treat military personnel, how we compensate them, and so forth. I don't think I've ever met a service member or a prospective service member who has expressed concern about going into the military or continuing to serve in the military on the basis that the military is not the most progressive employer in the nation. So perhaps you're hearing something different than what I'm hearing. Where is this coming from?
Sir, the survey data done by the Defense Equal Opportunity Management Institute, by various marketing agencies that work under the Department of Defense, suggests that the reason that women are leaving in droves, with a retention rate only 1/3 that of men through 10 years, only 1/2 through 20 years, is because of family concerns. And perhaps anecdotally, because I think these anecdotes are really important, Senator, if you go to somewhere like Harvard Business School, you will seem like the entire 75th Ranger Regiment has decamped to the classes up there. And you ask them why they would leave. Why would these extraordinary soldiers leave a unit as high speed as the Ranger Regiment? And they will tell you that the bureaucracy, especially around personnel, weighed them down. And they no longer felt that they could realize what they wanted in their own lives in military service. That's what we're trying to change.
Okay. I thank you for your answer. I struggle with this one. I struggle with it a lot because, again, what I hear from people, they're worried about equipment, they're worried about how we treat them, how we train them. I've never once heard somebody say, I was going to go into the military, but I'm not going to because the DOD is not the world's most progressive employer. Ms. O'Connor, I'd like to follow up briefly on a conversation you and I had in my office. Do you believe that U.S. government under the 2011 authorization, or for the 2001 authorization for the use of military force, has the authority, either under that act or under any iteration of the Defense Authorization Act, to capture and indefinitely detain a U.S. person on U.S. soil.
Senator, I think that that issue has not been resolved by the courts, but as a policy matter, the President has said that he would not allow that to happen during this administration.
Does the statutory text convey that authority, in your opinion?
Well, the statutory text of the 2001 AUMF, doesn't get into detail at that kind of level. But the courts have held that the government has the authority to detain enemy combatants, and a U.S. citizen is not immune from being detained. The courts have also held that U.S. citizens have due process rights and constitutional rights. And that's why the administration has a practice consistent with those requirements of having the Department of Justice do specific constitutional analysis whenever a detainee is captured who might be an American citizen.
Okay. I see my time's expired. I do have some concerns with this. I do think the Defense Authorization Act contains language that suggests the government does have this authority. I personally believe that's unconstitutional for the United States under any circumstance to detain a U.S. person on U.S. soil indefinitely. That's why we have a Bill of Rights. The Bill of Rights does protect that in a number of respects, and I believe that those who argue otherwise are reading too much into precedent that shouldn't apply here. Thank you.
Thank you, Senator. And by behalf of the Chairman, Senator Blumenthal.
Thank you, Mr. Chairman. I want to thank all of you for your willingness to serve. Each of you has extraordinary qualifications and background in public service and in private life, and I just want to express my gratitude and support for your nomination. Let me ask you, Ms. O'Connor, you may be familiar with the recent reforms that have been adopted, first by Secretary of Defense Hagel and now adopted as well by Secretary Carter, relating to the discharge correction boards and veterans who have suffered from post-traumatic stress, who may have been discharged with less than honorable or bad conduct discharge. A number of these discharges are the result of post-traumatic stress, which was undiagnosed and untreated at the time. This issue has acquired a momentum. I advocated that the policies be changed. Senator, then Secretary of Defense Hagel agreed, but the use of the boards has not been as widespread as we hope, perhaps because there's been insufficient outreach to those veterans. But the basic idea is that those veterans who suffered from post-traumatic stress, whether post-9/11 or in previous conflicts, whose conditions were undiagnosed and who were discharged less than honorably, ought to have the opportunity of seeking review now that their conditions could be diagnosed. As you know, at the time of the Vietnam and Korea conflicts, there was no such thing as post-traumatic stress as a diagnosed condition, although shell shock, battle fatigue caused many of our nation's men and women in uniform to be discharged for those kinds of conditions. So I'd like your commitment that you will be an advocate insofar as there are legal issues here, and a lot of the human conditions are surrounded by legal issues. I don't mean to make light of them as a lawyer, but they will take some intervention, advocacy, and outreach, and I'd like your thoughts and your commitment on that issue.
Senator, I appreciate everything that you said, and it's obviously an important issue. It's not one that I've had an opportunity to work on yet at the Defense Department, but if confirmed, I do give you my commitment that I will take the issue seriously and work on it, and would be happy to work with you in your office on it.
Thank you. I would appreciate that. It's a bipartisan issue.
Could I add to that, Senator, if I may? Sir?
Yes. Sorry.
I followed that issue closely. The New York Times, NPR have written lengthy, very moving stories about that situation. I think you're right that Secretary Hagel's memo of 2014 did change how these things are being handled. They went from a 5% success rate at the BCMRs to a 40% success rate. Just this week, in my capacity, after reading those stories, I issued a new memo circulated to all the military service organizations and veteran service organizations, saying that same presumption that Sec Hagel put in place applies retroactively, going back as far as we have service members, and irrespective of administrative finality or whatever statute of limitations periods might have expired, you have the right to a de novo review on these issues with the presumptions that have proved successful over the last year. So I am cautiously optimistic that we will get after this problem in a way you see satisfying.
I really appreciate that answer, and I perhaps should have directed my question to you in the first place, so thank you, and I look forward to working with all of you on this issue. Let me ask maybe all of you, on the issue of behavioral and mental health care, which Senator Donnelly raised, as you know, the suicide rates continue to be much too high among our veterans, but also among our military active duty, and including our reserves and National Guard. And so I would like, again, your commitment that you will focus on this issue. I don't ask you for a plan right now, but my own answer to the question that Senator Donnelly asked you about the adequacy of the numbers of providers and mental health care professionals available to our military is that, in fact, the number continues to be inadequate. It is in the rest of civilian society as well, but it remains so in our military as well. So, again, your response, and I hope your interest and commitment on this issue.
I oversee the Department of Defense Suicide Prevention Office, and I'd be happy to come talk to you about the work. I agree with you. We had 443 suicides last year across all components. The reserve component has proved persistently high, and we do have some plans in that regard, and I look forward to coming by and talking to you about them personally.
Thank you. I would welcome that. Thank you very much, Mr. Chairman. Thank you all.
Thank you, Senator. On behalf of the Chairman, Senator Tillis, please.
Thank you, Senator Reed, and thank you all for being here. And you should be proud of the fact that you're here despite the questions you may get asked by any one of us. I'm sure you and your family are very proud of this moment. Ms. O'Connor, I want to come back to you. I'm not an attorney, but I want to come back and see if I can understand the thought process behind what I believe you said was the extraordinary circumstances in the Bergdahl case made the statutory requirement to give the Congress 30 days notice something that the President had discretion to do, that somehow he wasn't in violation of the law. So just hypothetically, let's assume that Mr. Bergdahl, who's now going through court-martial, wasn't a part of that transaction. Let's assume he's there today, and his captors have threatened, because I think you mentioned that his life was being threatened. That was the extraordinary circumstance that the President was operating under. So let's assume he's there today, and the same captors come to the President and say that they will release him if the President will transfer the current Gitmo detainees to the United States. Do you think that that would be an extraordinary circumstance where the President could again potentially not obey the law, given that it was used in the prior example?
I think that no, and I think that the statutes that govern the restrictions to bring detainees to the United States, which are multifaceted, they are restrictions on literally transferring people from Guantanamo Bay to the United States, but they also include restrictions on modifying buildings, constructing buildings, purchasing buildings for, for the purpose of, and there's funding restrictions, and when you put all of them together, it's not possible.
Can you conceive of any circumstance where the President may have a basis, in your legal opinion, to violate the transfer of detainees under any extraordinary circumstances?
No, the position is that the restrictions that are in place now prohibit the transfer to the United States of the detainees who are at Guantanamo. And the Attorney General testified as to that yesterday. She's the Chief Legal Officer of the Executive Branch. and I agree.
Yeah, I
with
like that position. I just hope it's one that's maintained through the remainder of this administration. I did have a question on the AUMF, and it was, it relates more to, in the time that I've spent either in the Middle East or down at Fort Bragg and other places, that I hear the call for a new authorization for the use of military force, but it seems to me that the presidential policy guidelines, in other words, what the president chooses to do within the context of the AUMF, have been, more often than not, some of the impediments that we think are men and women in uniform or the officers are confronted with when making decisions about engaging the enemy or engaging ISIL or any of the other enemies, particularly in the Middle East. So what am I missing in terms of this, from your legal perspective, I should say, what would a new AUMF do for you and for the department that can't already be done under the current AUMF?
The current AUMF authorizes all of the activity. It's the legal basis for what we're doing, and it authorizes all of the activities that we're engaged in. To your point about the combatant commanders having the authority to do what they need to do, I mean, I will tell you, I would be very concerned if they thought that they didn't have the authority to do what they needed to do, and if confirmed, I would make it an extremely high priority to do whatever I could as appropriate to assist them, because I think what they're doing is critically important, and I think that the legal teams that work with them out in the field, those are military lawyers, do as well to help them work through to be able to do exactly what they think they need to be doing.
Mr. Weiler, and what could, depending upon what happens over the next few months, your tenure could be long or short. I think Mr. Donnelly, or Senator Donnelly, asked you a question about some of the priorities and things that you're interested in. I'd like for you to communicate those back to my office. But if you feel like you only had a year to do things, what do you hope to accomplish? Just very quickly, you can get into the details later in my remaining time. What are going to be your top priorities, the things that you're just going to hammer on if confirmed?
Senator, first of all, would be taking on the challenge of the creation of this new office and ensuring that, one, the reserve components understand that there's no lessening of commitment to them. Second would be families. Really, this has been a lot of the work that I've done in the commercial sector. So I think ensuring strong families makes a strong service member, makes a strong military. So that would be another area that I would focus on immediately.
Thank you very much. Senator Sullivan, please, on behalf of the chairman.
Thank you, Mr. Chairman, and appreciate the witness's testimony. Let me ask Ms. O'Connor, I got to tell you, I'm a little bit disturbed by your answers on some of these legal questions, and I think the White House has admitted they violated the law with regard to Bergdahl. So you're kind of twisting and rationalizing that is disturbing to me. Let me kind of dig a little deeper, though, on kind of what you see your role is. So I'm a former Attorney General, the state of Alaska. And like the Attorney General of the United States and or other Attorneys General across the country, there's always a bit of a big issue. So let me just ask you this. Where do you believe, as the General Counsel, if you became that, of the Department of Defense, your loyalty lies? So let me give you some hypotheticals. Does your loyalty lie to the rule of law and the American people, or does your loyalty lie to the President or the Secretary of Defense? So let me try to unpack that a little bit. Let's say that you get confirmed and you look at what's going on with this Gitmo decision, and you really look at the law, the NDAA passed last year. There's a lot of us who think the President, and he's got a reputation for this, his administration certainly does, is pressing the limits of his executive authority, ignoring the rule of law. Let's say that you take a hard look at it, and in your heart of hearts, you think what the President's doing on Gitmo is against the rule of law. He doesn't have the authority to do it according to the law. Okay, so you conclude that. Let's use that as an assumption. And then you have the White House and the Secretary of Defense come and say, you know what, we're doing this. Our general counsel, the attorney general, they kind of agree. So get on board. What's your role? Where's your loyalty? I'm very disturbed by your answers because you seem like you're flipping all over the place to support the president policies when I believe your loyalty is to the rule of law and the American people. What would you do in that hypothetical? Would you support the president, or would you say, I can't do that, I think it violates the law, I'm going to resign?
Senator, you're absolutely right. The commitment that I have and that I would have if confirmed to this position is to the rule of law. It's to the Constitution, first of all, and to the rule of law.
So would you resign in that kind of case? If the White House said, hey, I know you think that the Gitmo move by the president is illegal, but so what? We don't. Get on board. What would you do? And again, I'm assuming that you concluded, you've got a strong legal background, that what they're doing is illegal. What would you do?
I just want to address the other things you said, and I'll answer that. My commitment and true north is the Constitution and the statutes that guide the department and the government.
Even though your answer on Bergdahl seems, boy, I think that's real weak, to be perfectly honest. I think the White House has admitted they violated the law there.
As I explained, I was not involved in the analysis. I've read
But you were asked
what
for
the
your legal
department-
opinion.
My
And
legal
you,
opinion.
and your legal opinion was that was good to go. I think that's a real stretch. It really, to be honest, I was looking fine at your confirmation. I'm very, very concerned right now, given your answers in this hearing. So I'm sorry, I know I keep interrupting. Can you finish? Would you resign if you thought the president was violating the law on Gitmo?
So just to get back to the point you were making about the Bergdahl exchange, what I want to make clear is that I didn't provide any legal advice on it. I have read the letters that the department has
said you
sent
thought it
to
was
this
legal.
committee. I'm explaining what the letters to this committee written by other people have said.
Okay, let me just real quick, if you can just answer, would you resign your position if you were the general counsel of the Department of Defense, you read the law and you thought the president was violating the law on Gitmo or anything else relating to DOD-related matters? What would you do?
My commitment is to the rule of law.
Got to answer
and-
my question.
Well,
Don't dodge me. What would you do? Would you resign, or would you kind of get behind the president and say, roger that? I'll just make the best legal argument I can to support you, Mr. President. What would you do?
I would give my very best legal advice to the Secretary of Defense, because the position that I'm seeking confirmation for is to be the General Counsel of the Department of Defense.
Wait, so you would, even though you thought remember, the question assumes that you thought Gitmo was illegal, and they're going to go forward with the president's plan anyways. What would you do? You would get behind them and support them? Is that what you just told me?
I have not said that.
I thought you just said that.
No.
Okay, then just answer the question.
If confirmed as the General Counsel of the Department, what my responsibility would be to give my very best, not political, my very best legal advice consistent with the Constitution and the statutes that govern the Department to the Department. And that is what I would do.
Okay, you're not answering my question. I've asked you 5 times. If you thought that what the president was doing and the Department of Defense was doing was illegal with regard to Gitmo, and the president and the Department of Defense said, we're doing it anyways, and you voiced your opinion, and you told people you thought they were violating the law, then what would you do? Would you resign? Or would you say, okay, I'll give my best legal argument and try to put the best face on this? So just to answer that question directly, would you resign?
I have not yet seen a situation that presents anything like that.
It's happened in U.S. history before, right? You've had attorneys general resign when the president is, the Saturday Night Massacre under the Nixon administration. You had senior officials resigning, saying, I'm not going to do that because I think it violates the law. So it's a legitimate question, particularly with this administration that presses the envelope of their constitutional legal authority on a regular basis. So can you give me an answer to that question?
Certainly, as you note, there are circumstances in history that present that, but a lot comes before anybody gets to that point. And among the lot that comes before anybody gets to that point is collegial interactions and debate amongst the lawyers involved, I would engage in that, and I would engage in giving my very best legal advice consistent with the Constitution and the statutes to the Secretary of Defense.
And if the president moved forward on something you thought was illegal, you wouldn't resign?
As I said, a lot would come before anybody would get to the few instances in history where that has happened. It's not a common thing that happens. What happens is that lawyers engage, lawyers talk. I would very vigorously make my voice known and my legal analysis known. I would give advice to the Secretary. I would certainly talk to the Attorney General if that was what was warranted. And we would work our way through it. It's impossible to address the hypothetical that you're laying out.
Okay.
Thank you, Senator Sullivan. On behalf of the Chair and Senator Ayotte.
Thank you, Chair. I want to thank the witnesses for being here and for your service to the country. I would like to follow up, Ms. O'Connor. I don't know if you're familiar with Section 1036 of the 2016 Defense Authorization, but it is specific to the closure of the U.S. Naval Station in Guantanamo. And it actually says very clearly that the DoD cannot appropriate or spend any dollars to close or abandon the naval base in Guantanamo, to relinquish control of Guantanamo, or to implement a material modification to the treaty between the United States of America and Cuba about Guantanamo. So this provision of law, do you think that the President is going to Cuba, the Cubans want Guantanamo back, given this provision of law in place, do you think the President has any legal authority to implement a material modification to the treaty between the United States and Cuba? And also, do you think he has any legal authority to close, abandon, or relinquish control to Cuba, given this provision of law that is in place and is the law of the land right now?
I understand that Assistant to the President, Ben Rhodes, spoke to this a couple days ago and said there was absolutely no instance in which this was going to happen.
So my question to you, there's no instance this is going to happen, but my question to you, you're the lawyer, you're the general counsel, is there legal authority, yes or no? Is this law valid that we passed in this committee, and should the President follow it?
The President should follow the statutes that govern the executive branch, and the Department follows the statutes, has a practice of, and does follow the statutes that govern the Department. I have not examined that provision. My understanding is that nobody has raised any prospect of there being a plan of this happening. If I were confirmed and it were raised, I would certainly look at the legal issues that were involved in it. I'm not familiar with what exactly the processes are.
What role do you have right now?
Deputy General Counsel.
Well, you're Deputy General Counsel. You're not familiar with this part of the defense authorization on Guantanamo?
Senator, there are numerous deputy general counsels with different portfolios. I have not had the opportunity to dig into the law around that particular provision, and I think one of the reasons I haven't had an opportunity to do that is that absolutely nobody within the executive branch has suggested this is going to happen.
Well, I would suggest that this is a valid law. Not only should no one in the executive branch suggest that this is going to happen, but it would be against the law. And I would hope as general counsel, you would tell the President of the United States it's against the law. It's plainly in the 2016 defense authorization. So I want to know from you, these are some tough questions. If the law says plainly, for example, on Guantanamo, you can't modify the treaty, you can't change the base, you can't, and also with obviously the transfer of the detainees to the United States, are you going to tell the President that here's what the law says, so you can't do it?
My advice, if confirmed to this position, will be to the Secretary, but yes, absolutely, I will interpret the statutes and advise the Secretary according to what they say.
Excellent. I also want to ask you about another provision pertaining to Guantanamo. It's something I worked on in the defense authorization. There's a section of 137 of the NDAA which requires the Secretary of Defense to submit an unclassified report to Congress regarding the individuals that are being held at Guantanamo, their backgrounds, and to provide a list and information with the exception of obviously anything that would jeopardize intelligence sources and methods. And this is late. It was due January 24th. Somehow the administration was able to submit a plan to us, but hasn't actually given the American people the information about who's there, what do we know about them, how dangerous are they. And this is very important to me. And so I expect that report to be submitted really before this process on nominations go forward. So I hope that you will go back and ask the department to finish this report. It couldn't be a more important time to have this report in light of the president's submission of this so-called plan to close Guantanamo. Will you do that?
Yes, Senator, I understand that that report is in development.
I think it's very important that we receive it right away. And it's not going to continue to be in development. This is important to us if we're going to look at these issues. I also want to end with a final question that's very important to the men and women that serve our country, and especially our New Hampshire National Guard. I recently learned that our airmen at Al Udeid Air Base in Qatar are being forced to live in potentially unhealthy facilities and may be getting sick from black mold exposure. Despite efforts by the local command there and repeated requests of our airmen, the situation's not been fixed. In the last month, approximately 100 New Hampshire Air National Guard members experienced unacceptable living conditions, and I'm told that this black mold is coming out of showers, it's in the bathrooms, it's in the curtains, and that some of our airmen are becoming sick and having symptoms as a result of it. So I would like to ask all of you, especially Mr. Carson and Mr. Weiler, to have your commitment, if confirmed, you commit to looking into this issue, doing everything in your power to fix, to work with OSD and make sure that our men and women aren't being made sick by facilities, that obviously they're already in a difficult situation with the service they're giving us, meaning we're asking them to do a lot for us and we're grateful for their service. So I'm just asking you, I don't want to hear from my Guard that they're getting sick from mold. You know, obviously they put their lives on the line, and I'm asking for a commitment from both of you that you will follow up on this.
Senator, as the acting principal deputy, I'll do more than just commit to you. If confirmed, I will immediately look into it and try to have something back to you by the end of next week with an explanation of what we're doing, a mitigation strategy about that. First I've heard of that, but I will take it for action and get back to you immediately about it.
I really appreciate it, and if you need any additional information, we're happy to follow up with you. Thank you.
Thank you. On behalf of the Chairman, Senator Graham, please.
Ms. O'Connor, what is your portfolio as Deputy General Counsel? What lanes do you work in?
I have a variety of responsibilities. One of them is litigation, which covers a wide range of areas. One of them includes the Office of Hearings and Appeals. I provide legal advice as requested by different components on different topics and as requested by the Secretary on various topics.
Have you ever been asked to give legal advice about Guantanamo Bay?
Issues that touch Guantanamo Bay are within my portfolio, yes.
So why did you have a hard time answering the question about the statute?
The question was posed as a hypothetical about the president relinquishing the base, I believe, and that's just not an issue that I have dug into.
I was here late. Did you say the president could not transfer prisoners by executive order? Is that correct?
The president, what I said in response to the questions about whether the NDAA restrictions prohibit transferring detainees to the United States is that the current statutory provisions prohibit transferring the detainees who are currently at Guantanamo Bay to the United States. That's why the administration's plan that was submitted on Tuesday seeks to work with Congress to have those restrictions removed.
But do you agree without Congress's approval that you can't do that?
Yes.
Well, let's go back to the language by Senator Ayotte. It says pretty clearly that you can't modify an agreement regarding Guantanamo Bay with the Cubans. Why is that confusing compared to this other provision?
Senator, it's not confusing. I just haven't read it recently, and so being asked to give a formed legal opinion on the spot is difficult.
Fair enough, fair enough. The future detention. If we captured a high-value target tomorrow, does this administration allow for low war detention?
Yes.
Where and how long?
Senator, the 2001 AUMF as
Now, I know we have legal authority to detain somebody as an enemy combatant, but my question is, if we caught someone tomorrow and we wanted to give them that designation, go through the court proceedings to say you're an enemy combatant, where would we hold them and for how long?
There are not state-specific limitations on how long somebody can be held.
What's the longest someone, has anybody been designated an enemy combatant during the Obama administration for detention purposes?
I think I cannot discuss that in this setting.
Okay. Where do we put?
Because it's classified. I mean, just to be
Okay.
clear about where that is.
I can't think of any, but maybe I'm wrong. They may have been. Where do we put these people?
Where detainees have been detained on the battlefield or on the battlefield.
In U.S.
There are case-by-case determinations made that involve all of the agencies that are involved in these
I'm talking
processes.
about tomorrow. If we
Excuse
caught
me?
somebody tomorrow, where would they go and how long would we hold them?
So again, there are issues involved there that can't be discussed in a public setting, but the...
I don't buy that. I don't believe that we're compromised. Do we have a secret jail that I don't know about?
Let me answer the question this way. Our combatant commanders and the forces that we have in the field have plans that are available to them to detain. They address these issues on case-by-case basis.
Do we have the ability to detain, hold somebody as an enemy combatant in Iraq?
Do we have the authority to do it?
Yeah.
Yes.
Really?
We have the legal authority to do that, yes.
So, well, that's groundbreaking for me. So U.S. forces, if they captured somebody in Iraq, they could hold them under U.S. custody as an enemy combatant.
They can detain enemies picked up in Iraq, yes.
And we can hold them as an enemy combatant for an indefinite period of time without talking to the Iraqi government?
But certainly what
Can we do that in Afghanistan?
What we're doing in Iraq
I'll
is
tell you, you
working
can't do
with,
that in Afghanistan.
with partners. What we're doing in Iraq is working with partners.
Here's my question, of which this is disturbing. There is no legal authority for the U.S. forces in Afghanistan to hold someone under U.S. control as an enemy combatant. We gave that up when we transferred everybody from Bagram to U.S. control to Afghan control. There is no legal authority for us to hold somebody in Iraq under U.S. custody as an enemy combatant for an indefinite period of time. We just don't have that power. And I just want to know why you think we do.
Senator, my understanding is that under our international legal authorities as well as our 2001 AUMF, we do have the authority to capture on the battlefield and to hold.
So it's your testimony that an American soldier in Iraq, if they stumble upon somebody they want to capture, they can hold that person in U.S. custody in Iraq, ship them to America, and without the Iraqis being involved?
No, I didn't say that. In each place, there are different
It's
forces,
quite the
there are
opposite.
different agreements
We
with the
gave
different
that
partners
power
that
up.
we have.
It's quite the opposite. We don't have the authority to do that. So anyway, thank you very much for your testimony.
Thank you, Senator Graham. Senator Sullivan's asked for additional time. Senator Sullivan.
Thank you, Mr. Chairman. I wanted to follow up on some questions that Senator King had talked about on the Army end strength. And so, Mr. Carson, Mr. Weiler, I'd like to just get some of your thoughts on how you think about these issues. You know, one of the things that we do here in the committee, both in public and in private meetings quite frequently, is talk to the generals, talk to the military commanders at all the different levels. And I think it's pretty clear within the Army, General Odierno has wrote a couple op-eds on this, you know, even as he was finishing up as the chief of the Army, that going to 450 now is too risky, given the strategic 450,000 active duty forces in the Army, given the strategic challenges that we face globally. So there's a lot of talk about, you know, how we got to the 450 number. Sometimes people blame it on sequester. Actually, I'm pretty sure if you look at some of the documentation that the White House and DOD were aiming for that number pre-sequestration. General Odierno and others frequently now are saying, look, that's too risky for the country. 490, maybe 500. I think it should be north of 500,000. But how do you work through that when the generals are coming to you and you're the civilians in charge of manpower? When the generals are coming to you saying, hey, you know what? It's a new game out there. Russia's resurgent. ISIS is growing. The North Koreans are looking very aggressive. We need to change course here. When you hear that, and it's pretty much out there, trust me, we're hearing it. I'm sure you guys are hearing it, from the military commanders, who, to be honest, probably have a better sense of this than the civilian leadership. How do you react to that? What do? Do you agree that, let me just ask more direct, do you agree that 450 is a right size for the Army, or do you agree with the generals that are saying that's too risky, we need to change course and go to a higher number?
Let me take that, if I may, Senator. Since I was the Undersecretary of the Army and the General Counsel of the Army before that, I have been through many of the debates about the proper force structure for the U.S. Army. I believe what General Odierno has consistently said was that the 450 number posed risk, or perhaps significant risk, to execution of the Defense Strategic Guidance. When any commander comes to a civilian leader and says that they believe that the force structure isn't adequate to meet the mission, it is incumbent upon us not only to listen, because that is best military advice, but to do something about that. The 450 number, I do believe we would all like to see a larger Army.
So how do we get there? I agree with you on that.
More money. Every 10,000 people is about $1 billion to the Army budget. And so the question is, they need more money. If
But did you request that in the president's budget, to go to an Army of higher than 450? If you did, I didn't see it. I'd be pleased if you did, so correct me if I'm wrong.
No, the ramp down in the Army has been slow, and so they still are at above 450, even though that's the trajectory they're on. They have all said that that meets Defense Strategic Guidance, although risk is present on the horizon.
So if you're confirmed, will you commit to a number that's higher than 450 in your capacity as a senior civilian leader?
That will be an Army determination, not mine as the Undersecretary of Defense.
What if the Army came
Readiness.
back and said 490? Would you,
I would say,
if confirmed, would you agree with that?
I would say the Army could use 490,000 people, but the Defense Department would need $30 to $50 billion more a year in top line to pay for that.
So where are you on that issue? 450 or 490? In your strategic judgment, what's best for the United States of America?
I listen to the military leaders who will tell you that 450 can meet the Defense Strategic Guidance.
Well, they're not saying that now.
The chairman, I believe, would testify to that fact. I believe the other military commanders, I believe General Milley would tell you that while there is risk,
Just yesterday, General Milley said that one of the brigade combat teams that was slated to be cut, the 425 Airborne Brigade Combat Team, the only one in the Asia Pacific, he said, quote, I think it would be contrary to the strategic national interest to go ahead and pull the 425 at this time. My thoughts is that we should extend that. Do you agree with that assessment? I know that's just hot off the presses.
Sure, that makes sense to me, sir.
Will you commit to supporting General Milley if he recalibrates on what the Army needs in terms of force posture, not only with regard to the 425, but overall levels of the Army, that in his best military judgment is needed to keep our country safe?
Yes, absolutely.
Would you?
Yes, Senator.
Let me ask this one final question, Mr. Carson. You know, you were talking to questions with Senator Ernst about progressive military policies. I'm not 100% sure what that means, but sometimes I worry that we lose sight of what the main purpose of the military is. So do you have a sense of what the mission of the Marine Corps Infantry is? It's pretty succinct.
Sure, littoral combat, to dominate the littoral battlefield.
Close with and destroy the enemies of our nation?
Yes, absolutely.
Do you think that's still the #1 mission, no matter what? We got all these other things that we're talking about. Do you believe that that's the #1 mission that we should imprint in every member of DOD to remember and remind them that the #1 mission of our military members is to close with, destroy, and kill the enemies of our nation? Do you agree with that?
Yes, clearly.
Good. Okay. Thank you, Mr. Chairman.
Thanks, Senator Sullivan. On behalf of the chairman, I would thank the witnesses for their testimony, and the hearing is adjourned. Thank you.